My name is Michael Gerard. I'm on the faculty here, and I also direct the Center for Climate Change Law. And it is my great honor to introduce Joanne Scott, who is visiting from the University College London. Professor Scott is a professor of European law there, which she's been in that position since 2005. She's one of the leading experts on European law and WTO law and associated fields. She's also a member of the editorial boards of the International and Comparative Law Quarterly, the Journal of Environmental Law, the Journal of International Economic Law, and Transnational Environmental Law, to give you a sense of the scope of her scholarship, which is really very impressive, and I think you will all enjoy hearing from her. She's going to give a talk, and then I expect we'll have ample time for discussion.
Thanks very much. It's very nice to be here. Very nice to be in New York in the spring. I don't think there's a better city in the world to be in the spring. So I'll talk probably for around half an hour and try to leave lots of time for discussion and questions. I'm going to talk about a current research project. It's a project that's at a relatively early stage, so some of what I say will be in the form of hypotheses rather than established facts, but I'll indicate where I think that's the case. And my starting point for the talk today is one that will be familiar to you. I'm wondering how many people were in my class yesterday who was prototype when we talked about this. So the starting point for the talk is the decision of the European Union to include aviation in its emissions trading directive, to say that all flights arriving or departing in an EU airport, including transcontinental flights, have to acquire and surrender permits or allowances in the European Union's domestic emissions trading scheme. As a result of the decision to include aviation in the emissions trading scheme, the European Union is able to capture 60% of international aviation emissions, such as the intensity of air traffic, air travel to and from the EU. The EU's regulatory reach is actually really rather pronounced in this sphere. Now, I'm going to talk about this decision. Of course, it's important to say at the moment that there is change afoot in the world of European Union emissions trading. Yesterday, the European Parliament voted down a proposal to reform the rather ailing emission trading regime. So there's lots of uncertainty around the topic, and we can talk a little bit about that at the end. But it doesn't affect in any very direct way the thesis that I want to present in my talk. Although the European Union's aviation decision, as I'll call it, will impose relatively modest costs on airlines, you will know from reading the paper that the decision has been greeted extremely negatively. It's provoked a rather violent negative reaction on the part of many actors. So you will probably be aware that the big American airlines, United, American and so on, together with a trade association, the Air Transport Association of America, took an action in fact, the High Court in the United Kingdom, which ended up in the European Court of Justice, challenging the validity of the decision to include aviation in the emissions trading scheme. And if you haven't read the judgment, haven't looked at the judgment, I recommend it. It's a really very fascinating case. Partly because you had the phenomenon in the case of American NGOs intervening in support of the European Union, and you had the Air Transport Association of America standing up before the European Court arguing that the European Union couldn't do this because it was contrary to the Kyoto Protocol. So we ended up in a really slightly topsy-turvy world. It's a very, very interesting case. The European Court upheld the validity of the directive, and we can say something more about that later on. As well as litigation, the measure provoked legislative responses in a number of states. So the US Congress, for example, passed a blocking statute which prohibited US airlines from participating in the European emissions trading scheme. and giving the Secretary of State for Transportation power to enact measures that he considered to be necessary to ensure that American airlines were held harmless in the face of the functioning of the scheme. China is reported to have adopted a similar measure, although I haven't got access to the text of that. So, a very strong reaction politically, and also a lot of attention in academic circles was provoked by the EU's decision. And the kind of tone, or one element of the reaction in academic circles, was to suggest that this aviation decision is indicative of a broader trend in EU law in the direction of extraterritoriality. That whereas we used to consider it was just the United States which engaged in extraterritorial legislation, this was taken as one of several examples attesting to what one writer in the Harvard Law Review called a transubstantive shift in EU law in the direction of extraterritoriality. As the EU gets bigger, as the EU gets stronger, in some respects, the EU is inclined, like the United States before it, to act in a more dramatic extraterritorial way. And that got me thinking a little bit about the theme, more generally, of extraterritoriality in EU law. And I decided to kind of investigate that theme by moving beyond the climate change sphere and looking at a range of other areas of EU law. Some of them are cognate with the emissions trading examples, for example, international transportation, or environmental regulation, or the protection of public health. But some of the areas that I've started to look at are not cognate with the emissions trading example, but I've chosen them on the basis that there are areas in which controversies around the territorial reach of EU law have arisen. So I would include in that category areas such as financial services regulation, data protection law, and there are several other examples as well. So what did I find when I started to look at the question of extraterritoriality in EU law? Let me just very briefly present some of the kind of outline findings. The first outline finding is actually instances of genuine extraterritoriality are, I think, still extremely rare in EU law. Except when the EU relies upon nationality as its jurisdictional basis, the EU almost invariably relies upon a territorial trigger for the application of its law. European Union law almost invariably rests upon the existence of a territorial connection. Either conduct, the conduct in question takes place within the territory of the EU, or presence, the person who is being regulated is present within the territory of the EU, whether present in a stable way, for example, a company is established within the European Union, or is present in a more transient way, for example, a ship has arrived at an EU port, or an aircraft has arrived at an EU airport. There is a handful of examples of extraterritoriality. Perhaps the EU's directive on ship source pollution is an example for those who want to follow it up. And there are instances emerging in the area of financial services regulation that might be considered to be genuinely extraterritorial. So I would give as an illustration there the EU's derivatives regulation, the so-called EMIR regulation, which contains an anti-evasion clause which would allow the EU to regulate conduct outside the territory of the EU, even in respect of persons who are not present within the territory of the EU. But they're really quite isolated examples. Extraterritoriality is not, at present, a pervasive feature, a widespread feature in EU law. It's the first finding. The second finding is that the EU, similarly, only rarely relies upon effects-based jurisdiction. Now, some people think effects-based jurisdiction is extraterritorial, some think it's territorial. Whichever way you want to classify it, reliance upon effects is similarly still uncommon in EU law. We see some reliance on effects in the area of merger regulation, as is well known, and again in the area of financial services regulation, we see effects beginning to be relied upon a little more. So in the derivatives regulation, for example, EU law will extend to derivatives contracts which are concluded outside the EU, even on the part of persons who are not present within the EU, if the contract is likely to have a direct, I can't remember the exact wording, direct substantial, I have to check the exact wording, but a direct and significant effect within the territory of the EU. But still, effects-based regulation is relatively rare. However, what I did find was what I called, what I label in the paper that I'm drawing on, what I did find is that there is a phenomenon in EU law which is widespread, and it's a phenomenon that I label territorial extension. And by territorial extension, what I mean is that EU law regularly relies upon a territorial trigger, conduct presence, but requires the EU regulator to take into account, in reaching its regulatory determination, conduct or circumstances abroad. So the application of EU law is sparked by the existence of a territorial trigger, conduct or presence, but the application of EU law having been sparked, the EU regulator is then required to take into account conduct or circumstances abroad. Now, the Aviation Directive is an example of territorial extension. Its application is sparked by the fact that an aircraft lands or takes off in an EU airport. There's a territorial connection. But the application of the directive having been triggered, the EU regulator then has regard to circumstances outside the EU. Most obviously, has regard to the number, the volume of emissions that are generated by the relevant flight during the course of the journey that results in the aircraft arriving in the EU, or during the journey following the aircraft's departure from the EU. In fact, on a flight from San Francisco to London, only 9% of the carbon emitted will be emitted within the territory of the EU, and yet the aircraft operator will have to surrender permits for each and every ton, including the emissions which occur outside the territory of the EU. So I'm calling that territorial extension. And when you look at the areas that I've referred to in EU law, what we find is that this phenomenon of territorial extension is extremely widespread. It's pervasive in EU law. Now, sometimes territorial extension operates at the level of an individual transaction. So you cannot sell a product within the EU if the product has been treated with a particular chemical, even if there's no residue remaining of the chemical in the product concerned. So it's a classic production process method, a PPM, which has given rise to such heated controversy in international trade law. Transaction level territorial extension. But territorial extension also operates at what we can call higher levels. It operates, for example, it operates at a level that we can call an aggregated transaction level. That is to say, access to the European market is made dependent not simply upon the production process or the transportation process in relation to an individual transaction, but is made contingent upon behavior or conduct or circumstances surrounding a group of transactions. So let me give you an example to try and make that clearer. In the area of maritime transport, the EU says classification societies such as Lloyd's of London, can only perform regulatory functions if they are recognised by the European Commission. In order to gain recognition, the European Commission will scrutinise not simply how well those organisations perform their functions within the EU, they will scrutinise how well they perform their functions on a worldwide basis in every port of the world in respect of every ship, regardless of the nationality of the ship. So access to the EU market is not rendered contingent simply on, are you going to do a good job when you enter the EU market? It's rendered contingent upon the performance level achieved by the organisation in question globally across the world. There we're seeing individual transactions being bundled together, being aggregated. Territorial extension also operates at the level of firms. In order to gain access to the EU market, the EU will scrutinise the governance or organisation of foreign firms. And territorial extension will also operate at a country-wide level. Access to the EU market will be rendered contingent upon the regulatory capacity or the legal framework prevailing in the country from which the product or the service originates. Let me illustrate with the Aviation Directive to try and make it a little bit clearer. With the Aviation Directive, territorial extension operates at a transaction-specific level, first of all, because the EU regulator takes into account how many emissions have been emitted during a single flight. So the single flight is the transaction. But it also operates at a country-wide level, because the EU says we will also take into account, in making a determination about how many allowances you have to surrender, we will also take into account whether the third country from which the airline originates has itself put in place legislation to regulate the climate change impact of flights. If the third country has put regulation in place to regulate the climate change impact of flights, then the EU will no longer require the flight to be included in its own emissions trading regime. So there the EU is seeking not just to regulate individual flights, but it's seeking to serve as a norm catalyst to try to encourage third countries to change their regulatory framework to try to tackle the problem of climate change associated with aviation. So this phenomenon of territorial extension, the EU regulator takes into account, is required to take into account as a matter of law, conduct and circumstances abroad when it applies European law, even though the European law in question is triggered by the existence of a territorial connection, is extremely widespread. And territorial extension, I think, serves as a mechanism of norm projection for the EU. While it remains within the boundaries of territorial jurisdiction, so it looks relatively uncontroversial from that point of view, it serves as a relatively robust mechanism of norm projection for the EU, especially when it operates at a higher level. Because when it operates at a higher level, what European law is doing is it's performing a kind of bundling function, and it's allowing the existence of a point of territorial connection to then spread out to capture transactions, circumstances that really have no direct connection in and of themselves with the European Union. Let me give you one more example, because I see some blank faces. I don't think I'm explaining it very carefully. Let me give you one more example to try and kind of illustrate, try and tease it out. So, the EU has it's a very mundane example, but they're sometimes the easiest and the clearest. The EU has a directive that regulates the training of seafarers. For any seafarer to gain employment on an EU ship, that seafarer will either have to be trained within the territory of the EU, or where the seafarer is trained abroad, their access to employment will depend upon the country from which they come having a system of training which is comparable to the system of training that prevails within the EU. Now, if you're a seafarer from the Philippines and you've gone to a really excellent seafarers school, you've received a top-notch training that is in every way comparable to the training that you would have got in the EU, that doesn't matter to the EU at all. All that matters is whether the country from which you come has a training system in place which is comparable to the EU. So it's country-level territorial extension. So the EU is, in effect, extending its regulatory reach to the training of seafarers who have no intention of ever entering the EU market. And EU law is being diffused through this phenomenon of country-level territorial extension to circumstances that, taken individually, have really no connection with the territory of the EU. And I don't know, Anu, whether it's a little bit like in your Brussels effect paper, you introduce in your paper the category of legal non-divisibility. I don't know if you would consider this to be an illustration of legal non-divisibility, but what it certainly is, it's the very careful design of legal instruments serving to expand the regulatory reach of EU law by aggregating transactions, only some of which are actually territorially centred upon the European Union. And thinking about the concept of territorial extension in the context of the debate about, is the EU becoming like the US? Is there really a trans-substantive shift in the direction of extraterritoriality? Made me kind of wonder whether the EU is, by engaging in territorial extension, which as I suggested is a relatively robust mechanism of norm projection, whether the EU is beginning to act a little bit like the United States, although in a slightly different way, and whether the EU is being hypocritical, criticizing extraterritoriality on the part of the United States while engaging in something which is very similar itself. And this is where I start to be a little bit more speculative. I'll make two observations, the first of which is really a hypothesis, and the second of which is more concrete. So the first observation is, I think there is something quite distinctive about territorial extension in EU law. Because I think the phenomenon that I'm describing, I think the EU legislation which gives rise to territorial extension is characterized by what I call an international orientation. That is not to say that none of the measures that I'm describing are unilateral, because many of the measures I'm describing are unilateral. The Aviation Directive is unilateral. But even where the measures are unilateral, I think they're characterized by an international orientation. They, in the main, operate in pursuit of objectives which have been internationally agreed. And they are characterized by a kind of contingent quality, which seems to me to be very important. They're characterized by a high level of substantive flexibility. The way that the EU defines the norms leaves room for substantive flexibility. And they're characterized by a high degree of provisionality. So the EU is projecting its norms, but it's projecting its norms in a rather contingent way. It's leaving room in the design of the instruments for a process of co-determination about what the right regulatory response to the global or transboundary problem being tackled should be. It's not that the EU is saying, this is the answer, we've worked it out, and now everybody else has to do exactly the same. It's saying, this is a problem that has to be tackled, and we've reached a provisional conclusion about how one might set about tackling it, and we're going to use this strategy of territorial extension to bring firms, countries to the table to talk about what it is that might be required. We see that in the Aviation Directive example. The Aviation Directive preceded 10 years of failed negotiations in the International Civil Aviation Organization. Even after the directive was enacted, the EU has made it absolutely clear, we still want to talk. This is not intended to silence a global conversation on the topic. It's intended to constitute a kind of background, a default position against which that global conversation will take place. And we're not trying to preempt what the outcome of that global conversation should be. We're defining in only the most open-ended and flexible terms what it is that would be required by way of a regulatory solution for the EU to back down, to step back and to disapply, if you like, its own norms. So I suggest in the paper, looking at several of the examples that I used, that territorial extension in EU law is different from extraterritoriality, partly because there is, of course, a territorial connection, but mainly because EU law is characterized, or EU law measures giving rise to territorial extension are characterized by this kind of international orientation. I then spent a little bit of time looking at the EU's attitude to extraterritoriality in US law. Is the EU engaging in double standards? Is it doing something here that it would criticize if the same thing were done by the United States? And then the results are, I think, quite interesting. When you look at the EU's reactions to US extraterritoriality, and I did that by looking at the EU's annual trade reports in relation to the US. I did it by looking at EU intervention in international law cases involving the US, Kyoto, among others, where the EU submitted a brief in support of neither party. Sousa, the earlier case, they also did the same. And when you look at the EU's response to US extraterritoriality, in some cases what they call extraterritoriality is actually territorial extension, but when you look at the EU's response, what you find is the EU doesn't condemn extraterritoriality or territorial extension out of hand. It's very willing in the Kyoto case, for example, to accept that universal jurisdiction as a valid basis for exercising jurisdiction. But the EU says, but nonetheless, if you're going to exercise universal jurisdiction, you should make sure that domestic remedies in the other country have first been exhausted. There should be a contingent quality to universal jurisdiction that make, in that case, the US exercise of jurisdiction second best, following a failure to provide a remedy in the country in which the conduct took place. Similarly, in the very famous shrimp turtle case before the WTO, the EU does not condemn what was, in essence, in that case, country-level territorial extension on the part of the United States. It says, yeah, you might need to actually make the importation of a particular good contingent upon the manner in which the good has been produced, and even possibly contingent upon the regulatory framework prevailing in the third country concerned, country-level territorial extension. But if you're going to do that, the European Union says, you have at the very least to talk to those other countries first, to try to arrive at a multilateral solution before you impose a unilateral solution. And when you do impose a unilateral solution, you have to make sure that your solution is sufficiently flexible to ensure that it leaves room to accommodate the particularities of the circumstances prevailing in the other country concerned. In the area of financial services, and Catalina will be able to say more about this, it seems to me that the EU's reaction to extraterritoriality, probably territorial extension in US financial services law, has been a little bit the same. The EU has said, we're not complaining that Dodd-Frank applies to companies outside the US, but what we're saying is, can't you take seriously the notion of substituted compliance, which is a little bit like the EU concept of equivalence, and recognize that there are different ways in which shared objectives can legitimately be achieved. So I think the EU is actually behaving in a rather consistent way. It's engaging in territorial extension, but its territorial extension is imbued with an international orientation. And when it criticizes US extraterritoriality, it does so not on the basis that it's extraterritorial, but on the basis that the measures in question are not imbued with a sufficiently pronounced international orientation. I'm looking at the time, I'm just going to conclude, but I think I'll stop there so that we've got time for comments and questions. Okay, yeah.
Sorry if I misunderstood you, but just one question. Because the policy of the EU, in particular the one referred to the aviation emissions, is following, as I think you said, international regulation. Couldn't it also be said that it should take into account international principles, like they also agreed common but differentiated responsibilities?
So the Aviation Directive is a unilateral measure in the sense that international aviation is essentially unregulated. When the Kyoto Protocol was concluded, the International Civil Aviation Authority was charged with developing a framework for regulating international aviation emissions, but conspicuously failed, absolutely failed. So after 10 years or so, the EU said, okay, so now we're going to act. And we're going to act in a really quite radical way, because we're not simply going to include in our emissions trading scheme flights that depart from the EU, but we're also going to include flights that arrive. And of course, in doing that, what it's trying to do is to spur action by the International Civil Aviation Authority. And serious negotiations have started to take place. Whether they'll lead to anything, we don't yet know. But there is more impetus to the negotiations now than before the EU acted. There can be no doubt about that. And in the light of that, the EU has said, we're going to postpone, we're going to stop the clock, is the phrase they use. We're going to stop the clock for a year in relation to this directive to give the international community time to arrive at its own regulatory solution to the problem. So it's a very, you can read that in one of two ways. You can say the EU's capitulated. It's got too hot in the kitchen and the EU's bailed out. Or you can say, this is a great example of what I'm describing as an international orientation, because the EU saying, our intervention was only provisional. It was intended as a catalyst to provoke progress at the international level. If that progress is happening, nobody is happier than us. Then the question is, did the EU design its directive in a way that is in keeping with international law principles? And that would be an important question in assessing the degree of international orientation of the measure. And if I have one criticism, actually, of the Aviation Directive, it's that it did not sufficiently take into account or reflect the international law principle of common but differentiated responsibility and respective capabilities, because it doesn't distinguish in any way between different airlines, flights from different countries, and so on.
Thank you.
Here, and here, and here. And here.
Okay.
You were first, because I know less about financial services regulation than anything else.
I'm not sure I'm going to talk about financial services regulation. I'm just thinking about the broader picture.
Yeah.
And so in some ways, I think what is happening is that multiple actors are contesting for the transnational regulatory space, right? It is really sort of a game where you could think, well, maybe we can do this all internationally, and then you realize you can't because it's just complicated. And you see some actors, the US, taking the first step and saying, well, we'll just do it. And in a way, you could, I'm asking you whether this is a fair depiction of what's going on, that the EU at some stage just has to decide, either just gives up and will become a rule taker, as so many other countries in the world, or it also wants to be a rule maker, and then it has to get into the game of extraterritorial or jurisdiction in one way or another, whatever you would call it.
Yeah, I mean, I think that's a really helpful framing of what I'm describing. But I think I'm also trying to argue that the EU, though it's entering that game, is playing the game in a different way. That the EU is, because of what I'm describing as an international orientation, I'm not sure it's the best description to capture what I'm getting at, but the EU is much more contingent, much more provisional, much more open to influences elsewhere. So the EU is situating itself within that regulatory territory, transnational regulatory domain, but it's not trying to occupy that transnational regulatory domain. In one really clear example, because I need to do some kind of detailed case studies to back this up, but one that's been done by other people already is in relation to EU initiatives in respect to forest governance, for example, the EU so-called FLEG regulation, which is designed to promote sustainable forestry in mainly developing countries. And there we see an illustration of what I'm trying to get at, because there the EU is saying, you know, we're going to impose some really quite strict obligations on you, third countries, unless you enter into a bilateral agreement with us to agree upon standards that should govern forestry within the country concerned. And the standards are derived at are not EU standards, co-determined standards arrived at in a relatively open, at least the evidence that I've read by Zeiland and Overvest suggests, in a relatively open and inclusive way. So I think, you know, that's as much what I'm trying to get at. I mean, I guess there's two main things I'm trying to get at. One is just follow on from Annie's work. I think actually the category of legal indivisibility is probably more important, a more important central part of the story that has been recognized so far. And then secondly, is it just something a bit different about the way in which the EU is engaging in transnational governance in a way that isn't captured by the, oh look, the EU's becoming extraterritorial in the same way as the United States. No, George, you're not next.
So to build on the spirit of Karina's question, so if there is this kind of contest of the regulatory space, and in your example, EU moves first, proceeds to regulate, extend its territorial reach, to use the term, and then US responds by basically enacting a blocking statute. They're saying, we do not want you to comply. So I was wondering if you could offer your prediction of how this will actually unfold in the context of the emissions, and whether your review of earlier episodes of extraterritoriality, when we, for instance, have had Europeans enact blocking statutes, when Americans have started with extraterritoriality, and whether we learn anything from those that would help us probably predict what will come out of this.
Yeah. You know, it's a dangerous business predicting, isn't it? Especially in relation to this, because there's so many possible readings of what's currently going on. I mean, I think one of the most interesting things that we saw happening before the one-year postponement was put into force was the US adopted a blocking statute. So you've got this kind of clash of norms. That's quite unusual, actually, because often you have kind of conflict equivalence clauses that allow for the accommodation of that, but you didn't in this example. So you have this clash of norms. The EU statute actually says, you know, if you don't comply, you suffer quite dramatic penalties. The US statute doesn't say anything about penalties. So then there's intervention by private actors. Private actors actually have to make an assessment about what the best way to proceed is. And what you saw happening was aircraft leasing contracts being rewritten to ensure that aircraft operators would comply with the European Emissions Trading Scheme. So private sector, private actors made a kind of risk assessment of the kind of the nature of the conflict that was taking place and actually came out on the side of the EU. And I think that's quite an interesting phenomenon as well, because we're starting with kind of governments by states, but we're ending up actually with private actors making quite an important play in terms of resolving the conflict. But, you know, the EU, like I think the US to some extent, very often does include conflict equivalence clauses in its measures. That would be part of the international orientation. If you genuinely can't comply with both sets of norms, then we'll back that. Sharon.
Thank you. You know, this is probably the hottest issue out there, it seems to me, is this extension of norms and regulatory measures. And I guess I wondered if you would comment a bit on the extent to which you think EU practices are pure versus commingled with other objectives. And one of the concerns that has arisen in the US measures that have offshore effects are that you know, environmental measures can be bundled with things that look like competitiveness measures. That's not true in antitrust. And frankly, I start from listening to you feeling that what the EU is doing here is actually going well beyond most of the US instances of extraterritoriality by embedding those norms. But the problems that, one of the problems that has arisen in US cases is this bundling of objectives, so you can't really say that, or at least raises doubts that the, say, environmental measure is purely an environmental measure. So I guess one dimension is if you could comment on the sort of purity, and when you say it's speaking to international objectives, is it the UK view of that consensus? Or really, is there a consensus and it's just reaching, you know, the norm? And I guess the other is, in the context of a moment in time when we're talking about a U.S. transatlantic economic integration framework, I mean, the biggest stumbling block in the past in advancing this was mutual recognition of national regulatory standards, and a real inability of the U.S. and the EU to accept questions around comparability. So you mentioned that aspect, and I wonder if you could just say a little bit more about it.
Yeah. I mean, you know, I just don't know in the end, well, no, let me put that differently. I would not for one moment suggest that when the EU adopts measures of this kind, and I would include the Aviation Directive as an example, that it is acting purely to serve environmental goals. No, I think it's absolutely acting to preserve its own competitive position in its domestic marketplace. You know, and actually the EU doesn't deny that. There's nothing particularly sanctimonious in the language. You know, they're very clear that this has a dual objective. It's to prevent carbon leakage, to protect our own position within our own market, and it's to serve as a catalyst for third country and or global action in response to a problem that the international community recognizes exists. So there is an international consensus that aviation emissions need to be regulated. There's just no consensus about how that should be achieved. I mean, there's absolutely no consensus about how that should be achieved, partly because of the issue of convert differentiated responsibility. So I think the EU is pursuing, and it's nearly always in these examples, pursuing a dual objective. But I don't think that's a problem. I don't think it matters. One has to kind of, you know, recognize that there might be constraints imposed by bodies like the WTO to try to weed out obviously protectionist measures and the like. But beyond that, the fact that they're pursuing a dual objective is reasonable. The equivalence dimension, so I think what we're seeing here is not mutual recognition. You know, I think there is, I read your paper recently on financial services regulation, whole state control. I think the era of mutual recognition has actually largely gone. I think what we're seeing is equivalence, and I think equivalence is very different from mutual recognition. Some people call it managed mutual recognition, you can call it different things. But the EU is certainly trying to ensure that the standards are in some way comparable in serving the objectives concerned. And one of the most important parts of my project actually will be to try to understand better how equivalence is being applied in EU law. That's why I presented my thesis of an international orientation as a hypothesis, because I think it will be necessary to look concretely at particular examples to ask whether that kind of flexibility that is claimed to exist as a result of the language of equivalence really does exist, or whether the EU is trying, in fact, to export its norms in a rather more static and less kind of reflexive way. It's helpful, thank you. Nice to see you as well. I haven't seen you for a long time. George.
Following the logic of your analysis, would it make sense, or would it be revealing to take a look at also in conjunction with this the positions the EU takes in these international negotiations that it is seeking to catalyze? Yeah. If one were to say that the EU were to approach these negotiations in an intransigent fashion, I'm not saying it does, but if it were to be demonstrated, that would do something to your thesis, I think, considerably. I wonder if that's part of the enterprise, or it's certainly a rather different inquiry, and rather difficult to conduct. To what extent does flexibility characterize the EU as a negotiating party as compared to flexibility in its architecture of its regulations?
No, I think that does have to be part of the inquiry, but it often won't be. It just won't be relevant, because in a way it follows on from Merritt's comment. Sometimes there may well be international agreement on an objective. You know, it may be defined at really rather a broad level in the G20, for example, in relation to financial services, but not a corresponding detailed international negotiation taking place. But where multilateral negotiations or bilateral negotiations, because the EU is using this to catalyze as a catalyst to promote bilateral as well as multilateral negotiations, are taking place. And I think that's going to be absolutely a relevant consideration. And in fact, most of the measures that I've looked at place more emphasis upon the bilateral than the multilateral, interestingly. And you know, when I decide which concrete case studies, I think it's difficult to choose case studies, and I'm not quite sure, but I think climate change, financial services, fisheries, and maybe maritime transport are the ones I'm kind of looking at. And in those areas, I'm certainly going to have to conduct that kind of
to look at the dynamics.
Yeah. Chuck. Be nice.
I'll try. I might have it. But you're a friend, so I'll see if I can muster a section. There are two ideas here. So one is the conventional idea that states, international actors contend for power advantage or hegemony that they can get in international space. And then the question is naturally, is every effort to extend domestic rules or to impose rules domestically which have effects, extraterritorial effects, is part of the strategy aiming to achieve that end. And a second view is that there's something different going on here, that nations or blocks of nations actually are trying to resolve problems of great moment to them, and they understand they can't do that by themselves, and they probably can't depend at the moment on international organizations to do that. And so they take unilateral action, hoping to improve things immediately, but contemplating and indeed hoping for the possibility that there'll be real deliberation. Others will come up with equivalent solutions that generalize the review. And that's why equivalence plays an important shift from mere mutual recognition, which allows for transactions but doesn't achieve the common goal, and equivalence, which achieves the goal, even if it doesn't wind up with an assertion of power, because each country is able to do it in a way most conformable with its own interests, is so important. Okay, so if there's anything new going on here, it's the shift towards the idea of equivalence, and then there are particular triggering mechanisms, unilateral actions aiming to induce equivalence. Now, there are two aspects of that. One is there's a long history, long meaning in the post-war period, there's a long history moving in the direction of establishing unilateral action as a valid trigger for equivalence-seeking deliberations. And that's a central motif in WTO law from tuna dolphin, trim turtle fishermen. But it's not a novelty, it's actually been consolidated, and it's not that it's incontestable, but it's certainly not, it's there. Second, and I think more important, is that however suspect the EU is from all kinds of points, I mean, I don't want to absolve you and your sclerotic EU life from.
Simply nice.
No. I mean, I just reflecting the current American view of this. Assuming that all vices, you have all the vices of a nation state, plus all the infirmities of not being a nation state. Is what I wanted to say. Nonetheless, accepting all of that, for whatever it's worth, there is a distinctive feature of the EU, which is it's the first major state-like constellation that actually has to practice the principle of equivalence in its domestic regulation. Because it only works, it does the directive, the form of the directives, the form of the judgments of the ECJ, the Court of Justice, are exactly like that. Here's a norm. You have to. It isn't that you have to. It's not a prescription. It's a set of desiderata, and there's sometimes a default position or something. But you have to find a way within your national context to satisfy the conditions of equivalence. So there's a naturalness. That is this idea of equivalence is both native to the EU in a way that has not been feasibly native or plausibly native to other nation states in the international system. And I think that doesn't mean that motives can't be mixed, and that every time the EU does something, it can say we're natively equivalentist or whatever the word for that is, and therefore you should roll over and deliberate with us. But it does shift things in a fundamental way. It makes the EU probably maybe a little more supple in negotiations. The EU, if you compare the U.S. and the EU in this, it's not so clear to see. But I think that needs to play. I mean, both of the centrality of equivalence as the sort of tertium ad quem, where things are heading, if there is directionality, and the fact that it's easier for the EU, relatively speaking, to get there because of this constitutional affinity.
So, I mean, that's helpful. I mean, apart from the first comment, which was basically, I don't think this is very original, which is not that helpful, but... It
has broader precedence.
Yes, it does.
This is a culmination.
Yes.
And it makes manifest in a particularly acute way a set of things which have been more dispersed in the international legal system and in WTO law than they have been in the action of the state.
Yeah. So, I mean, absolutely. So the first thing is, and in a sense, other people have done this as well. I mean, Anna is one of them, but there's just a relevance to pointing out that the EU is doing this, because there's a ready tendency to say in the literature that the EU is multilateral while, there's a kind of crude dichotomy gets drawn, which is just actually not very helpful. So partly that's, it's relevant just to look at the EU as a separate actor. And my main focus for this project is the EU. I've got a little comparative dimension in this paper, but my project is not essentially to compare the EU and the US. And the second point, to what extent the EU's internal governance structure is relevant to this story is really important and really interesting. It's an argument that Ronja Roberta has made in her recent paper, that the EU is not simply exporting norms, and we've made it in the experimentalist field, but it's exporting processes, governance approaches. And I think that's something that I would want to look at here. Connected to that, I'm not sure yet, but I think what I'd quite like to do is to examine side by side unilateralism as it operates within the EU at the level of individual member states. What role does member state unilateralism play in driving EU regulation forward? Similarly, the role of the EU in the international domain. But my inclination is absolutely to suspect that your thesis is correct, that the EU's structure is such and the process of arriving at norms within the European Union is such that the EU is going to find it easier to have an international orientation of the kind that I described. Okay, it's time to finish.
Joanne, thank you very much.